Most families don't realize that Virginia's wrongful death law is one of the strictest in the country. Did you know that if your loved one is at all at fault, even as little as 1%, that could bar your family from recovering damages? Today I'm going to explain what most people don't know about Virginia wrongful death claims and why acting quickly could protect your family. I'm Ryan Wynn, owner of Wynn Injury Law here in Virginia. I help families navigate Virginia wrongful death claims and wrongful death lawsuits. If you find this helpful, make sure to reach out. We're here to guide you every step of the way. Losing a loved one is devastating, and the legal system can seem confusing while you're grieving. Virginia's wrongful death law is unique in several ways that most people do not know. First, there's a strict contributory negligence rule. Unlike most states, Virginia does not allow partial fault. Even if your loved one is only 1% responsible for the accident, your family may not be able to recover anything. That's why proving the other party is fully at fault is critical in a Virginia wrongful death claim. Second, only a personal representative of the deceased estate can file a wrongful death lawsuit in Virginia. That could be the executor that's named in a will or a court-appointed administrator. This person acts on behalf of the statutory beneficiaries, which include the surviving spouse, children, grandchildren, parents, siblings, or other dependents, depending on who is next in line under Virginia law. Understanding this hierarchy is essential to making sure that your family's rights are fully protected. Third, the damages in a Virginia wrongful death case bypass the estate. That means any compensation awarded goes straight to the family and is protected against creditors or debts. Wrongful death damages in Virginia can cover lost income, loss of companionship, and grief, while punitive damages have specific caps and medical malpractice cases have separate limits set by law. There are no caps or limits in Virginia for wrongful death awards. Now, it's important to know that a wrongful death claim is different than a survival action. A survival action addresses your loved one's pain, suffering, and medical expenses prior to death, and those funds usually go into the estate. But the wrongful death claim is about the family's losses. At Wynn Injury Law, we guide families through both types of claims to make sure that nothing is missed. When you work with us, we start by collecting all critical evidence: police reports, medical and coroner records, witness statements, and expert opinions. We do this to build a strong case, proving duty of care, breach of duty, causation, and damages. Our goal is to make sure your Virginia wrongful death lawsuit is thorough, accurate, and positioned for the best possible outcome. Finally, timing is crucial. Virginia gives families only 2 years from the date of death to file a wrongful death lawsuit. Waiting too long can permanently bar your right to recover, no matter how strong the case is. Acting quickly ensures that we preserve evidence, interview witnesses, and preserve your family's rights. If your family has lost a loved one due to someone else's negligence, I know how overwhelming this process can feel. But you don't have to face it alone. At Wynn Injury Law, we handle the complexities of wrongful death claims so the families can focus on healing. Call us today to protect your family's rights and start the process for seeking justice. If you found this video helpful, please share it with anyone that may need to know more details about Virginia wrongful death law. Your loved one's story deserves to be heard, and your family deserves to be protected. We are Wynn Injury Law, and we are here for you, Virginia.